G'day. Welcome to the Financial Bloke Podcast, the podcast for people seeking the wisdom needed to grow their family's wealth and live a happier, healthier and more prosperous life. My name's Ben Law and I am the Financial Bloke. As humans, we seem to be mainly motivated to build our family's wealth to become more financially secure now and eventually live a comfortable retirement. The fact is, no one wants to work their guts out forever. What's often overlooked is what happens to all that wealth you've built once you pass away. Now, I want you to ask yourself a couple of questions. Number one, how do I want my wealth distributed when I die? And what's the likelihood of that actually happening? Two, do I want my family to get all my wealth when I die, or do I want to make a bunch of lawyers rich? Three, do I want my kids to fall out over my estate? Four, do I want the government to get a big chunk of my estate in taxes? And number five, if you're in business or in the business of farming, will the business be able to keep going when I die? Now, these questions have just scratched the surface, but you get my point. Estate planning is vitally important if you want to keep your hard-earned wealth in your family. And that brings me to today's guest. Today, I'm meeting with Tim Rivett. Tim's a lawyer and one of the really good guys. I got to know Tim professionally over the years as he helped a number of my financial advice clients with things like asset protection, structuring, and estate planning. Tim's the managing partner of Robert Harris Rivett, based in Yeppoon, Queensland. And this isn't my first episode with Tim. We had a great chat back in episode 1 about financially assisting your family. So if you haven't listened, I'd highly recommend you check it out. Today, Tim and I are going to explain what estate planning is, why just having a will isn't enough, the common mistakes as an estate planning specialist he sees people make, and the things you can do to start sorting out your estate planning. But before we start today, we need to keep all the lawyers happy with a disclaimer. The information contained in this podcast is general in nature and for educational purposes only. It's not financial advice, it's not legal advice. No one should act on the information without appropriate specific advice for your particular circumstances. I'm a former financial advisor and I've chosen to no longer be licensed, and I cannot and will not give you specific personal advice in this podcast. Now all that's behind us, let's get cracking. Welcome, Tim.
Thanks, Ben. Great to be here.
We've kept you happy with the disclaimer.
Yes, thank you. I think I might have written that disclaimer. I can't remember.
You did. Excellent. Now, a common misperception, Tim, is that most people think that if they've got a will, then by default they've got an effective estate plan. So I want to start with a really down-to-earth, common sense definition of what estate planning actually is.
Yeah, sure, Ben. So from my perspective, an estate plan is all about achieving peace of mind, and peace of mind to cover the what-ifs, okay? So we call it using all the tools in the toolbox. A will is a fantastic document that forms a critical part of an estate plan, but is not an estate plan. There are other tools in the toolbox that we need to use and rely on before we can achieve that peace of mind to protect the legacy for whoever you leave behind when your time comes.
Because a will is only a part of the puzzle, I suppose would be the right way to put it, wouldn't it?
Definitely a part of the puzzle. And if it's a will only, you haven't covered things like the incapacity and, a few more tools in the toolbox, which I'm excited to run through today.
Yep, excellent. Now, what are the stats on how many people die without a will these days? Because I know I saw it many years ago and it shocked the hell out of me when I saw it, but what do you think it is about now?
Yeah, so Ben, bearing in mind that 98% of statistics are made up, I've got one for you that comes from a number of reputable sources. The consensus, which is a pretty shocking statistic, tells us that 52% of adults do not have a will in Australia. That's an alarming statistic. That's a touch over half. So, you go to a barbecue with 20 people in the room, chances are 10 or 12 of them don't actually have a will, which is far too high. Now, the stats do skew towards an older demographic, so we do find that older people tend to think a little bit more about it and they're a little more proactive. But certainly the younger, healthy people, it's not high on their priority list. And from my perspective, it should be, particularly if you've got debt, you've got kids, you've got spouses to consider. All those types of things mean that just because you're young and healthy, that you shouldn't have a proper estate plan.
And not having a will, I mean, the problem I've run into over time is people will say to me, Ben, I've got a will. And it shocked me the amount of time I'd send people back to say, okay, well, go find your will and have a read through it. And the number of people that have come back and say, for example, I have a will, but I can't find it. which is effectively if nobody can find the will, you don't have a will. Number 2 was I did that before I had kids or before I was married or divorced, and we didn't take that into account. And the last one is it just doesn't express our wishes, which is essentially as bad as not having a will, wouldn't you say?
Definitely. Sometimes a really, really old will or an inadequate will is actually more harmful than not having one at all, Ben, and we'll unpack that in a minute about the laws of intestacy. If you don't have a written estate plan, the government tells you what your estate plan is going to be. For those 40% of Australians who die without a will, the laws of intestacy will mandate and dictate exactly what happens when you go.
Yeah. So why do you think most people don't, or so many people, shall I say, don't have an up-to-date estate plan?
There's definitely a complacency and a reluctance to acknowledge and talk about our own mortality, Ben. That's a big one for us. It's the avoidance tactic that none of us really want to acknowledge that our time here is short. None of us are getting out alive. But I have so many conversations with clients around I won't care, I'll be dead, so why should I dedicate my valuable time to the exercise? Yeah, people maybe don't think they've got enough to justify the exercise, so they say, I don't own anything. But particularly nowadays, that's extremely rare that somebody doesn't own anything. We have superannuation. There are a lot of insurance policies buried in superannuation, and they can form a considerable part of somebody's assets upon death, particularly the life and the TPD insurance, that type of thing.
Just on that, I actually had a call from someone, a friend recently, and their daughter passed away in their mid-20s, and they came across that exact problem. She had virtually no assets in her own name, but she ended up having a fairly hefty life insurance policy within a super, and it had no plans have been put in place for that, and it turned into an absolute disaster for the family.
Yeah, we just finished an unfortunate post-death estate plan. A fellow who was young and healthy in his 40s, had one child, had no estate plan, and it's taken us about 12 months to negotiate within his life insurer to actually create an adequate trust to get them comfortable to actually pay out a $750,000 insurance policy for the benefit of his son. So again, shouldn't have been that hard, shouldn't have taken that long. An estate plan that was done properly would have made that far less painful, and it would have been a better outcome.
And the family needed the money when they needed the money, not 12 months
absolutely.
later.
Yeah, you're under pressure then. 12 months is a very long time for mortgagees to wait around, for home and contents insurers to wait around, for vehicles to lapse in registration, because a 10-year-old doesn't have any income, but his carer needs to drive a car around and house him. So, the reality is 12 months is far too long, and it wasn't done properly. What about from your perspective, Ben? What are the objections to people getting an adequate estate plan from your experience?
Well, the other thing is, Tim, I've found is that a lot of the times people don't want to make the tough calls. And it's too tough a discussion. So, for example, it's the old, it doesn't have to be equal to be fair, especially when there's business or farming assets involved. One child might come back and say, well, they're taking over the farming business and all the associated debts and risks, etc. And the other children may be living off farm. And then it becomes too hard. How do we deal with this? What are the decisions we're going to make? What are the conversations we're going to have? And it goes in the too hard basket. There's also complexities of blended families. So people have, the divorce rate now, I think, is 1 in 3. And I think I read the other day 40% of all, or 60% of all second marriages fail. And so blended families are becoming more and more prolific, and trying to work out how the hell do we deal with this if, we're a blended family. So, mum and dad remarry and they've both got children of their own. Difficult relationships with children can be another one. So in other words, they've got situations where there's problems in the family. So they just think, this is just all too hard to deal with it. And I think that's probably what I've found over the years is the major reason. And I've seen a lot of people over time, Tim, where they've got halfway through the estate planning with the solicitor and it's just gone in the too hard basket and they've just shut down. And I think an unskilled solicitor is probably another major reason. And what I'd say is they're not an estate planning specialist, or they don't understand it. Number 2, they've got poor interpersonal skills, so they can't explain all the issues really well. They might be technically really good, but they can't explain things to people. And they also sometimes fail to help people make decisions. And And I think that's a real problem. And from your point of view, do you see that, Tim? That people coming to you and saying, look, I've had a couple of goes with another lawyer, but I just can't get this done. I can't get it across the line.
Yeah, I'm glad you brought that up, Ben. I didn't want to be the one who raises that and is critical of my professional colleagues, but we do see that a lot. Estate planning requires a bedside manner. And there's lots of really, really good lawyers, just as there are really good doctors and other professionals who just don't have those interpersonal skills, as you mentioned. People don't know what they don't know, and they often need guidance and an opportunity to feel comfortable asking lots and lots of questions to tease out an estate plan that suits them. There are complexities in everybody's estate plan, whether you're a nuclear family or you're in business or you're a blended family. There's always going to be some questions and I guess some fear about what the outcome is. But like I said to you before, there are so many tools in that toolbox that we can pull out and use to implement that job and provide that peace of mind. But we do see lots and lots of incomplete estate plans. A lot of people tend to come to us on referral from other advisors to say these clients have had a crack at this before and they've never quite gotten over the line, which I understand. Lots of people are busy, particularly if you're in business or you have a busy family life. There's always going to be a priority list, and where does the estate plan sit on that? But because we're specialists in this area, we generally don't leave people alone until they've implemented their estate plan, even if it takes a little bit longer than everybody will have hoped. There's really nothing worse than starting the process and then stopping because you've already done the hard work, the psychological commitment to start the process. That's often what we say to people, Ben, that congratulations, your hard part is done. You've made contact with us and we've had our initial chat. The rest is up to us to really guide you through and be the project managers and the leaders through that process.
Yeah, and working together with the numerous other providers, so the accountant, the financial advisor, whoever, or the banker, whoever else needs to be involved to get it done. And it's funny, Tim, I used to have a saying in my office, which my team didn't necessarily like, but I used to always walk around the office and say, follow up, follow up, follow up until they reply or die. And the whole reason for that is our job was to make sure things got implemented. And when we hit the hard parts, we had to help make decisions and get things in place, because without the executed documents, that's both in an accounting world, in a financial advice world, or a legal world, the whole job's pointless, isn't it? You know, you haven't got it finished, you haven't dotted the I's and crossed the T's.
Exactly right. And sometimes, as we touched on before, a really, really old estate plan or an incomplete estate plan can sometimes be more harmful than having nothing at all. So that's why we tend to not let our clients disappear or disengage from the process until we've come to a point where we can say, well, this is good. Yes, it may need a review in 5 years, but hopefully that gives them the peace of mind, which, remember, is the name of the game.
Absolutely. And I used to find it was really interesting, you know, when you worked with an accountant, a lawyer and a financial advisor together for the client, is what would happen is each of you would have skills in different areas. And I used to spend a fair bit of time actually translating. So when people would get stuck and they'd say, oh, you know, my accountant's talked about the tax side of things and I'm just not really sure I understand it and I've got to make some decisions. So I'd be able to translate what they were saying into sort of everyday terms. And same as the legal side, it's, well, I'm stuck, but I don't know where I'm stuck. So we'd break it down and say, okay, well, this is where you're stuck. This is the hurdle we've got to get over. Let's break it down into something really basic and simple and easy to understand so that we can move over that hurdle and then keep going towards the end of the race. And I think that is a real trap that as professionals we fall into, is we know this stuff inside out. It is complex and it sometimes becomes difficult to translate that into everyday terms that people can actually not only understand, but they can actually make decisions around.
Definitely. And we also find that those joint meetings between advisors are the most productive of all. So what we'll try to do during a process is get the key decision makers and stakeholders in the same room, or at least on the same technology, depending on logistics. So it's really the lawyer, the accountant, the financial planner, and anyone else who's a critical part. That could be adult children, you know, who are part of more of a succession plan, I suppose, than an estate plan. But dedicating the time, but walking out of that meeting with a clear direction, as opposed to walking out of a meeting saying, well, here's 4 things I need to ask the accountant and here's 4 things I need to ask the financial planner. People can feel like they haven't really used that time productively and achieved anything, and they're more likely to disengage. So we find that if you can chisel off an hour or two with all the key thinkers in the room, you can walk out of that and the hard part is actually done, the lawyers can then go and talk about that implementation step.
Today's episode is brought to you by AgriCoach. You've worked bloody hard over the years and you've built a solid operation. But as your children grow up and start their own journeys, you're beginning to think about the next 5, 10, and even 15 years and how to keep driving the business forward and ensure a smooth and successful succession plan. Preparing the business, preparing the next generation, and preparing for your eventual retirement all requires a solid plan and a proven process. Unsure about the right steps to take? Head on over to agricoach.com.au/webinar to learn more about our Succession Proof Your Family webinar. AgriCoach, aligning families, growing wealth, and protecting legacies. And now, let's get back to the episode. Perfect. Now, what's the difference between having a will and an effective estate plan, Tim?
So the definition we use is that a will is actually part of an estate plan, but is only one part. So if you think about implementation of an estate plan, a will hasn't covered off any loss of capacity issues.
And by loss of capacity, you mean mentally that people aren't able to make decisions before they die.
Exactly right. So it could be something as horrific but simple as a car accident. So I'm in a coma, I'm busted for 6 to 12 months, I'm going to be okay, but somebody needs to help me manage my life while I'm busted for 6 to 12 months. Same example I gave you before. Somebody's got to pay the mortgage. Somebody's got to keep life going. Somebody's got to do life, Not everyone will wait 6 to 12 months for you to repair and make a decision. Obviously, the more common are later in life with the brain degeneration diseases, Alzheimer's, early onset, that type of thing. Strokes, serious heart attacks, that type of stuff where there's a permanent loss of capacity. A will's not going to help you. A will is only a document which kicks in upon the declaration of your death. Before then, it's just a piece of paper that's sitting on a shelf. So if you think about the components or the tools in a toolbox that you need to have an adequate estate plan, a will is very important, but it's not going to get you there. We can run through a list of what we perceive as an effective estate plan, just so that people have an understanding of, do I have one of them? No, I should probably go off and get one because I thought I had an estate plan, but actually I don't. I have a will and maybe an enduring power of attorney, which is one of the key documents for loss of capacity, but maybe they haven't covered off for life insurance, maybe they haven't covered off superannuation, maybe they haven't looked at trusts and companies and things that people have pretty commonly nowadays.
And so they could fall outside. You have a will that says this is what I want to have happen, but then there's all these other assets that could potentially fall outside control of the will and have unintended consequences. So the other couple of things, Tim, I thought of was family relationships maintained. I feel that's a really important one because when someone dies, emotions are high, people are upset, they're going through grief, they act not necessarily the best way. So I think having a good estate plan in place, if it's done properly, gives you less chance of destroying family relationships and also reduces the chance of estate litigation, which I think is a significant risk these days, is the fact that if your beneficiaries, if there's any unhappiness in the family about what you've received, and you see that in the business or farming scenarios quite frequently, in the sense that someone gets a farm worth $10 million or $5 or $20 million and maybe the off-farm siblings don't get anywhere near the same. So you can end up with estate litigation. And I think there are a couple of other points that I think are really important that people need to know.
Yeah, definitely. And they're probably the non-monetary aspects of an estate plan. So the peace of mind, it's just as much about creating that legacy. If you don't want your family to fall out upon your death because the plan wasn't done properly and there was no transparency, either not doing a proper estate plan or doing an estate plan and not necessarily letting anybody know what it says is a big one for us. And I know lots of advisors have different views on that. Should you do it in secret and they can just wait and understand it? But I'm very much in the pro transparency. Let's involve the next generation, because in my experience, surprise plus money plus grief is much more likely to end in a fight, I guess, which we would call estate litigation.
Yeah. I read something, Tim, a few years ago. I was doing a fair bit of research on estate planning, and there was some and again, statistics. So 98% of all statistics are made up. But there was some research came out of the US that was indicating that they believed that if people talked about what was actually in their will and their intentions before they died, it would reduce the number of estate litigations or family dust-ups by 85%.
Wow.
Which was massive. Now, obviously, this is all anecdotal evidence and there's a lot of assumptions, but still, even if it was a 25% chance that your family would not have a dust up over it or some sort of fracture in relationships, I think it's worth it. So for me, I was definitely with you. I was, as a general rule, always on the side of, discuss with your family what's in your will and your estate plan so everyone's around it so that there's not the chance of you having a dust up at the end, with the obvious caveat that there's some families that just doesn't work for and that becomes a personal choice.
Yeah, definitely. And again, that's just requires some thought and requires some guidance, and people know their families better than the advisors do, of course. But again, those tools in the toolbox, Ben, I keep hammering this point that if you ask a specialist estate planning lawyer what I can do to resolve this, your typical solicitor or lawyer just doesn't understand what tools are available. So one of my favourites is a memorandum of non-binding wishes. So it's a document that is non-legal, it's non-binding, but it's a lovely opportunity for people who are wanting to leave a legacy to create in their own words why they did certain things and what they would like to happen. So it's a wonderful document because it can be provided to the next generation either now while you're alive or upon your death. It answers so many questions for a lot of people about why certain decisions were made, why mum or dad wanted things done a certain way. Because once people pass away, you've lost that beautiful opportunity to have that conversation. And I completely understand why lots of people aren't comfortable having that conversation. They don't want to think about their own mortality. A lot of children don't want to think about a parent passing because it's potentially traumatic. But if you don't create that sort of document, then lots of people can box at shadows. They can say, well, this was done for this reason, and they can just make their own conclusions and make their own assumptions, and that can create friction.
For sure. And it's interesting, Tim, I've always suggested that you should review your estate planning regularly. So not leave it for 10 or 15 years. And I know normally people review those things when something goes wrong. So a family member passes away or they have a health issue. And I know my mum and dad just updated theirs only in the last couple of weeks because my grandparents passed away in last year at 97 and 92. So, there's longevity in the genes. My wife's got me around for a long time by the sound of it. How often do you recommend people should review their estate plan?
So we recommend 5 years. Ben, that's the best practice recommendation. Even if it's dusted off the shelf, have a think about it. It's all fine. Put it away. That's completely fine. It's actually a bit scary how quickly 5 years flies by, though. We've got clients, I've been doing this for a while, who we're on to their third sort of round of 5 years. And when we touch base with them or they touch base with us, they all say, I can't believe it's been 5 years since I've looked at this thing. But unfortunately, the average that we see for, I guess, just from our client base or that anecdotal evidence is people tend to wait 20 to 25 years to really consider updating their estate plan. And by that stage, maybe they've just been lucky that nothing has happened. So everybody's okay and everybody can look back at that. But a heck of a lot changes in people's lives in 20 to 25 years if you think about your phases of life. And it can often be a catalyst like retirement or grandchildren come along and those sort of big life issues where people think, wow, that's really time now. I've been thinking about it for 10 years on and off, but this is the one. But in reality, enough will change in 5 years that you should seriously consider it. Even if you consider it and nothing needs updating, you've done the exercise and you can put it away for a few more years and see what happens.
Yeah, and I'll concur with that. I mean, I was always amazed when I'd say to people, when did you update the will? And they'd think really hard about it. And they go, 5 years ago. Maybe it was 8 or 9. And you pull them out, it'd be 18 years. So I agree. It's always a lot longer than you think. Tim, we could talk about this. We could go in depth for days on some of these topics here, but what I thought we might do is just a really brief summary on what are some of the documents other than a will you might need. Well, even within a will, there's different sorts of wills, but what documents might you need to consider if you want to put an estate plan together? And again, obviously, this is not legal advice and it's not exhaustive, but what are some of the real, most important, shall I say, or the ones that most people need to consider?
Yeah, so again, Ben, tools in the toolbox. We've talked about our will. Wills come in different shapes and sizes. The two mains are a basic will as opposed to a testamentary trust will. And again, testamentary trust, it's a big topic. We can take a deeper dive into that some other day. But essentially, every estate plan needs a will, and testamentary trusts are a much more common way of implementing that intergenerational wealth transfer nowadays. The loss of capacity documents, your enduring power of attorney, and your advanced health directive. So they're two documents that will kick in while you're alive, but upon a loss of capacity. So you really need both. You need a will and an enduring power of attorney. An advanced health directive is more a contract between the medical fraternity and you, so that your wishes have already been expressed in terms of what medical treatment you would like if something happened to you. Really, really powerful document.
So advanced health directive is like you say, if I have a stroke or something happens, I don't want to be resuscitated, or, for elderly people, or it might be I don't want blood transfusions and things like that. It's the way you want to be treated by the medical fraternity. Is that correct?
Exactly right. So your enduring power of attorney will give discretionary power to your attorney to make those decisions for you. But if I said to you, would your elderly parents like blood transfusions? Probably not a conversation you've had, unless it's for religious reasons. So there's a weight of that burden to have to make that decision as an attorney when you really don't know what the wishes of that person might have been. They've lost capacity, right? So you can't ask them. Whereas that advanced health directive gets really, really specific in terms of medical intervention, and lots of people know them as a do not resuscitate document. So you're spot on, Ben. That's one of the key questions is, do you let me go or do you resuscitate me? And again, for religious purposes, some people aren't comfortable with blood transfusions, so they prefer to have one just so that their wishes are abided by, but has nothing to do with the actual attorney. It's really just a contract that's entered into between medical staff, medical professionals, and whoever's making that document.
And just to give a real world example, my grandmother, who was a tough lady, and her and I were very close, and I remember she said, I never want to be a vegetable. And the sad part is that she got to her 90s, she had a stroke, they did resuscitate her and treat her, and she ended up a vegetable in hospital, in a nursing home, which she would have absolutely been furious about. And so I think advanced health directives are something that really people should consider, and because they have real world consequences for people that don't want to end up in that position.
Definitely powerful document, and again, really important tool in the toolbox in terms of your estate plan. So more modern considerations, Ben, in terms of what's involved is superannuation and life insurance. So superannuation and life insurance actually fall outside of your will, or what you call your estate. So the way that your wishes are governed by that is either called a binding death benefit nomination or a non-binding death benefit nomination. So they're a separate document to your will, and they will say exactly what you would like to happen to, for example, your superannuation accumulation balance, whatever you've been stashing away with your employer, and any insurances that are contained within that. So really, really important document, because nowadays we're seeing a lot more wealth being generated within the superannuation environment. And if you've got a will that says, I would like my super to do this or that, that is not effective. Your trustees of your superannuation funds will generally completely ignore that. And if you don't have a binding death benefit nomination, the trustees of those super funds will actually decide what happens to that money, which again, big light bulb moment. Lots of people don't understand that that's actually a thing, that someone else can decide what happens to your money, which again is not really peace of mind.
And it can take a long time to sort that out, and also there can be significant tax implications if it's not done appropriately, if it's outside of your control. So yeah, I think that's a topic we could go into for hours.
Yeah, just in itself. We could take a deep dive into that. And then I guess for business people and people with complex structures, Ben, companies, trusts, that type of thing, it's always important to have those trust deeds and company constitutions reviewed, because again, those structures fall outside of your estate. Sometimes your will can play a role in the the changes of control, but very often it has to be some documentation outside of that. And then obviously your buy-sell agreements if you're in business and you've got partners or you're in a partnership, whether that's inside or outside of the family, and then insurance on top of that. So Ben, if you and I were in a partnership together, in business together, something happened to me and I've got life insurance that pays out my portion of the business either to you or the business gets gifted to you, that's a really important part of an estate plan, which will and should interlink pretty closely with your will.
Now, in your experience, what do most people miss, Tim? I mean, obviously that list of documents will tick off a lot of alarm bells, I'm sure, in a lot of people's heads, because I'll go, gee, I've got a will, and a power of attorney, I thought that was enough. And then they start hearing things like your superannuation doesn't fall under your will necessarily. If I've got companies or trusts, because a lot of businesses, especially in the farming world, operate in trusts or partnerships, etc. So that's I suppose you'd say the alarm bell should ring there a little bit. But what are some of the main things that people miss that we could duck into next?
Yeah, probably something I want to expand on is those complex structures. So the trusts and the companies, we do find a lot of particularly wills have been done in isolation where a lawyer didn't actually read the trust deeds or read the company constitutions to understand what would happen upon the death of someone like a director. An individual is a director of a company, or an individual who owns shares in a company, which tends to be different to, say, owning shares in BHP. I'm more talking about private companies, mum and dad companies, that type of thing, where assets are held or businesses are operated, that kind of thing. But the biggest faux pas we see, Ben, is the change in control under trusts. So really important to bear in mind that a trust will outlive you. It's its own legal structure, as is a company. So Ben, if you're the shareholder and director of a company and you die, that company will continue to exist. It just needs a replacement director and somebody's got to inherit your shares, right? So that's really, really important, because the constitution of a company might say, upon Ben's death, you have to offer those shares to a particular person or a particular class of people before you can decide to give them under your will to somebody else. So if you just have a will that says, I give them to my wife, Sarah, your business partner might actually have a first right of refusal under that company constitution that nobody thought about and nobody missed, or everybody missed. And suddenly your business partner is not very happy with the estate plan upon your death.
And that's a really important point, because it's not necessarily always about the asset. It's sometimes about the control of that asset or that entity, isn't it? I mean, because people look at it and go, okay, well, I've got this company that I'm running the business through, and let's say there's some cattle in there or some machinery in there, and a trading entity. But if you lose control of that, legal control, like it can be just as cataclysmic as losing control of the asset itself, can't it?
Definitely right, Ben. And the assets that are in that company may not necessarily be the farm or the land, but they might be such a critical part of that. They could be livestock, they could be plant and equipment. I came across one the other day, which was a farming operation where the plant breeders' rights to certain crops that had been grown for a couple of generations were actually owned by a particular company, and the family didn't actually understand that. They thought that Dad had all the plant breeders' rights in his personal name, and they were thinking about winding up the company. And we're saying, hang on a minute, if you get rid of that, then all those crops in the ground you've got no rights to actually farm, and your royalty arrangement with whoever created them is suddenly a problem. So again, do your homework, understand what's in them, and read the documents. And probably just as perhaps more importantly is those trust deeds, Ben. So the trust deed is kind of like your I don't mean to blaspheme, but the Bible of that particular trust. So the do's, don'ts, the real rule book about what happens. There are individual control responsibilities within a trust that a lot of people don't know or understand, because their accountant created that trust and told them it was a really tax-effective structure. But there are roles like an appointor or a supervisor or a principal. And again, the trust deed usually says upon the death of Ben, who's an appointor or a supervisor or a principal, the real power or control in that role goes to someone else. You really need to understand who that goes to, because we've seen some real shockers over the years, and people don't really understand that it either reverts back to the accountant, because that was just the way that the trust deed was created. And if you don't know about that, then you'll create a big mess just by complete accident.
Yeah. What's the words? Unintended consequences. I mean, the best laid plans are pulled apart with unintended consequences. And once you've got lots of documents in place, lawyers understand them. Lawyers probably enjoy them because they can use them as a valuable tool. But the average person doesn't know what all those words in a trust deed or a company constitution, and you can lull yourself into a false sense of security that, oh, my accountant's got hold of that, the lawyer knows what's going on. It won't have that big a deal, but it can have a catastrophic effect on things, can't it? I mean, the other one that I always think about is the tax liabilities. If things aren't structured appropriately, you could end up triggering some massive tax liabilities when someone dies.
Yeah, that's a huge concern, particularly nowadays, Ben, because we've often had capital gains tax rollovers between intergenerational wealth. So, for example, granddad or grandma may have in the ballot got a block, so the cost base on that block would be nothing or $1. That property could now be worth $10 or $20 million. So it's a high stakes. If you get that wrong, the tax consequences can be horrible. What a lot of people don't realise that there are lots of exceptions to the capital gains tax rollover rules. One of the ones we're really seeing becoming more common nowadays is beneficiaries, as in adult children who live overseas. This is that Australian trek rite of passage, as we sometimes call it. I'll go to London, I'll go to New York, I'll travel through South America, I'll meet someone and I'll never come home. Sorry, mum and dad, but I'm having your grandchildren overseas. We come across this very commonly, Ben, and it's a huge red flag for us. It's a huge trigger to really consider what the tax consequences for that beneficiary would be, which unfortunately is totally different to if that adult child was living and paying tax in Australia. The capital gains tax implications can be really horrible, and assets are forced to be sold just to pay tax bills, which is really a bit of a de facto death tax.
Yep. It's, again, unintended consequences. They leave the money to the kids or certain assets thinking I've done the right thing, but without knowing those tax implications, you could end up in a whole world of hurt selling assets you didn't want to, or even losing assets because you've had to sell them to pay the tax debts.
Definitely. And sometimes those assets are critical parts of the ongoing business. So, if you've got the country and the cattle, and unfortunately it's easier to sell cattle than it is country or mortgage country, you'll often find that will hamstring your operation because you just don't have the livestock that you needed to take advantage of the grass that you've got in a good season. So again, you really need to think about that. You really need to plan for that. And that is a critical part of the estate plan we often see overlooked.
And also loans in companies and what is it, UPEs, unpaid present entitlements in trusts. That's another big one, isn't it, Tim?
Yeah, really big one for us that accountants do great jobs out there minimising tax and creating structures that are good long term for families. So family discretionary trusts are a really, really, really powerful entity and something that accountants love and clients love because they can distribute income over the years across, adult beneficiaries or kids while they're at uni and all those good things. What happens though is often the accountants will say, well, to minimise your tax this year, we're going to lend money from structure A to structure B, and we'll just deal with that later on. Once you have a good year or something happens or you sell something, we'll repay that loan and square the ledger. And it's just a paper transaction. Yeah, it's just lending money from yourself to yourself, and can be really, really powerful structures, particularly if you've got a business that generates great cash flow. It can become your banker entity and you can lend that to other structures to do other things. But you have to understand the implications of those loans sitting on balance sheets upon changes of control. So remember, if you die, the company or the trust will outlive you, someone else comes in. If one of the entities has a right to say, I'm going to call in that loan now because I'd really like the cash because that's part of my inheritance, the wheels can really fall off a venture because you weren't expecting and planning to have that, and you've got to go back to square one. So intercompany loans, intertrust loans are really important. So if your estate planning specialist isn't asking for sets of financials across your business entities, then they should be doing that, and they should really understand. A big one is these UPEs, Ben, what we call unpaid present entitlements. I don't want to bore people or confuse people with what these are, but in essence, if a trust makes $100 in one particular year and you distribute that on paper amongst mum, dad, and 2 kids who are at uni, but no actual cash is paid to anyone, it's just an accounting and a taxation exercise, What actually happens is a beneficiary account is created in the financials of that trust, and it just sits there on page 19 of the financials, which nobody ever reads. And what you don't realise is if you do that year after year and the wealth that you're creating in that trust is considerable, the balances of those are just like a loan on call. So we've seen families that unfortunately enter into disputes. The first thing they will do is write a letter to say, I'm calling in my unpaid present entitlements now. Look at page 18 of the balance sheet. You owe me $350,000. I would like that within 7 days. And there's absolutely nothing the trust can do about that other than sell assets or go and borrow money or negotiate. And that's a real leverage point that we see. There are lots of things you can do about that, but you really need to understand that they're there and make a plan while everybody's okay and everybody's happy with one another.
And if you're a beneficiary and mum and dad are going through this, I mean, you need to start to understand how this works, because if you say you're inheriting a business, whatever business or a farm or something like that, and there's a trading entity like a company or a trust, and mum and dad die and you inherit that, but you inherit the control of the trust, but then there are these UPEs or unpaid present entitlements to, say, your other siblings, this can be a massive, massive financial implication for you as the person that's inheriting that trading entity or that business.
Definitely, particularly if that's the first you've ever heard of this structure, or some lawyer or some accountant says, what do you want to do about the unpaid present entitlements? And you say, what's that? I've never heard of that. Again, shock plus grief plus money. We've got that combination that can unfortunately create that friction.
Yeah. And what about beneficiaries with issues? That's another one you'd have to see from time to time, like disabilities, etc.
Yeah, often gets overlooked. So it can be things like rocky marriages, rocky relationships, not necessarily marriages, just any sort of spousal relationship. It can be physical or intellectual disabilities that require some thought, people who can't manage money. It could just be the spendthrifts, people with either gambling addictions or they're just really, really bad at money. And you just say, if I give them a few $100,000, what on earth are they going to do with that? Well, I can tell you what they're going to do with it. They'll burn it, and then they'll knock on the door of their siblings and say, I spent all my money. Can I have some of yours? And again, you've got that friction. So we always ask very poignant questions about how your beneficiary is going. Is everyone okay? How are their marriages? And it doesn't have to be anything that they've got going on in terms of vices, Ben. It can be as simple as they're in business or they're a professional, they're a doctor or an accountant or a lawyer, and they take risk every day in terms of advising clients. Do we really want inheritance assets to be put in their personal name so that if they make a mistake at work, because we're all human, do we really want to expose those assets to a negligence claim by something that happened at work? That needs some thought.
And it's really interesting, Tim, and correct me if I'm wrong here, but my understanding is if you end up with an estate litigation, so in other words, let's just say you've got 3 children, 2 are sensible and set up, and one's, let's say, a drug addict. And you go, little Ben's a drug addict. We don't want to leave any money to him because he'll just waste it all on drugs or alcohol or something like that. So we're not going to leave anything to them because they'll just waste it. We'll leave 50-50 each to the other 2 kids. And then that addicted or ill child comes back and says, no, you haven't provided for me. The courts will actually look very favourably on giving more money to the addicted or ill child. Is that correct?
That's exactly right. So it's a very, in my opinion, unfair system when it comes to those estate litigation scraps or fights, if you like. So what would happen is if you've got an estate and you've got beneficiaries who are all saying, I'm entitled, the one who's made either poor decisions or had an inability to create wealth over the years actually looks more deserving on paper. I'm not saying they haven't contributed themselves to that situation, but you almost get penalised for being conservative and generating your own wealth in that situation. So the example you just gave, 3 siblings, 2 of them do pretty well. One's completely busted when mum and dad die. If push came to shove, a court would look at that and say, oh, poor little Ben or poor little Johnny, compared with his or her siblings, he's really not doing very well. So I think we'll give him a larger percentage to make sure that he has advancement in life and is adequately provided for.
So it could go well in excess of, instead of a third, it could go, making numbers up, 50% to the child that's got the addiction, and it could go less to the other two that are doing quite sensible and doing okay.
Yeah, definitely. And sometimes that's part of the plan, Ben. If you have a child who has an intellectual or physical disability, we'll often find mums and dads who do want to skew that towards that child because they want to make sure they're provided for, and perhaps they don't have the employment prospects, or they're not fit for work, and they just don't have the means to provide for themselves. So sometimes that can be an essential part of the plan. But what you don't want is to not have the plan, or not have the plan done properly, so that a court has to intervene, because it always has implications on the family relationships, which is quite sad to see.
And the dollars added up. So if you find someone that, well, the danger is that, going, again, I don't want to harp on this, but you go back to the addicted child, they find a no-win, no-fee lawyer, or an aggressive lawyer that goes, wow, look at all this money sitting here, you deserve more. They'll aggressively chase that because the estate ends up having to pay the court costs.
Definitely right. And again, Ben, everyone's sick of hearing about it, but tools in the toolbox. There are lots of things we can do to protect those assets. Remember that trusts and certain companies fall outside of your estate. So if somebody claims on your estate, but a lot of the wealth is held in trusts, then they're all quarantined and protected, provided that you've thought about those changes of control. Then, you can minimise and not completely get rid of the risk of estate litigation, but you can really, really minimise that, so everyone has that peace of mind that they know that things are protected.
Yeah, and the other thing, Tim, I just want to flip it around a little bit, is the other side when families, let's just say you've got two children and one, let's say, has their own business and they're going fairly well and doing well for themselves, and say another child just has a normal job and they're not doing as well. And so parents say, well, child one is financially very secure, child two's not, so we're going to leave more to child two. That can also, or all of it to child two, I've seen in some cases. And that really breeds unhappiness in a family as well, because the ones that are doing well, that doesn't mean they're going to do well for the rest of their life. They might have a high risk business that could fail later on down the track, or do it a lot harder. And so that can actually breed discontent within the family, especially if it's not talked about the reasons why.
It definitely can. And again, that transparency, that's one of the reasons why we're promoting transparency, so that there is an understanding with the next generation about why certain things were done. And that can either be some disclosure or some chats while the estate plan is being drafted or implemented, or it can even be that memorandum of non-binding wishes document that I was talking about earlier, which is not quite a heartfelt letter from mum and dad. It's a little more structured than that, but certainly goes in with their own words about why certain decisions were made and why they would like their wishes abided by.
And also choice of executor too, Tim. Firstly, what is an executor? And the second thing is, why is it so important?
Yeah, so the choice of executor is extremely important. I find in some estate plans, it's something that's just, they spend 30 seconds on making the decision and then they all move on to talk about the assets. But an executor is a really, really important role. I think about it as more the train driver of the estate. So they have a lot of power and, in certain circumstances, some discretion to make decisions, but basically their job is to administer the terms of the estate plan or of the will. So the person you decide to take on that role is really, really important, because they may find themselves in a position where there is a challenge by a beneficiary or a piece of estate litigation, and they're the ones who have to decide whether to fight it or settle it or negotiate or do all those types of things. The other thing an executor can end up with is more of a trustee role. If you're creating a trust for a particular child, then your executor will end up likely being some sort of trustee for a lengthy period of time. So you really have to think about who you're appointing there, because it's generally an unpaid job. You can provide them with a stipend or some sort of executor's duties if you'd like to compensate them. But it's a pretty thankless job, lots of responsibility. So I find that one of the things that gets overlooked is people just assume that their family members are the best people for the job. But if you've got 3 children who don't necessarily get along, I don't think it's the best idea to appoint all 3 of them as the executors and hoping that in a time of grief when they've just lost a parent, that they'll put their differences aside and make common decisions that are in the best interest of all 3 of them. And that could be things like deciding to sell assets now as opposed to waiting a year or two. That's an element of discretion that an executor could have. But the likelihood is if they didn't really get along while they were alive, they're very unlikely to get along when they get thrown together in a job like an executor when they've just lost a parent. So, yes, it is something that kind of gets taken for granted. I would like my children to be executors. Sometimes you're better off having someone who's, say, a family friend, a little more objective. Maybe they know the family well enough to understand the dynamics, but they're not necessarily a beneficiary of the estate, so they don't have skin in the game as such, and it helps them maintain that level of objectivity.
And too, you see it, sometimes professionals fill that role too, Tim. I've seen that from time to time where families have made a decision and they've gone, geez, if I die, there's going to be a hell of a dust up, or I don't want there to be dust up. I'm going to get my lawyer or my accountant or whoever it might be to be the executor of the estate. And then that takes a lot of the pressure off as well. I mean, obviously that has some problems in itself doing that, but that's still a way of doing it in some cases.
Definitely becoming more common that people are appointing those key advisors, those trusted advisors, particularly the accountants, financial planners, and in some cases the lawyers, because they know the wealth, they know the family, they know the dynamics, they've heard all the stories over the years. So they're in a very unique position, but they're still not inheriting as such. So again, they're not a beneficiary. They can sort of see it for what it is, which is trying to implement the wishes of mum and dad, particularly if those key advisors were involved in the estate planning exercise. So they were in the meetings, they heard straight from the horse's mouth, they helped create the documents. They've got an intimate understanding of what mum and dad wanted and why certain decisions were made.
And it's interesting, one of the, I suppose you'd say, things I've seen in wills over the years done by certain lawyers is to mention, it's not legally binding, my understanding, is mention professionals in their will. So they say, if something goes wrong, go see my financial advisor, Jim or Mary, and they know where all my financial stuff is, and that's the first place to start. Take guidance from them. And that can help kids be able to go, okay, well, what do I do next? Where do I go about these things? What did mum and dad, what don't I know? Because again, unintended consequences. And that can be a really good way of pointing it. Would you see that in that memorandum of wishes, I think you called it earlier, or in wills themselves?
Yeah, definitely in the memorandum. So I wouldn't sort of put that in a will, because don't forget that will can be admitted to probate and become a bit more of a public document with the Supreme Court, whereas the memorandum is a private document, a secret document if you want it to be. We do them with basically a list of key advisors. So
perfect.
Financial stuff, who's the financial advisor, who's the stockbroker, who's the accountant, who's the legal person, so that if you're a brand new to the process, you've been appointed as an executor, either you didn't know, because people often don't tell people that they're appointed, or they're the adult children and the preference of the family was to sort of keep the kids in the dark until after death for whatever reason. Everyone has their reasons. Then they've got a place to start, and they at least can start to put the pieces together about who they should talk to when they're ready following a passing of a family member.
Yep. Okay, Tim, what are 3 things people could do right now? So if you're sitting at home, you're listening to this in the car, the tractor, or while you're at the gym or something like that, and you think, righto, I need to address this. I need to start to do something about it. What's 3 things you think people could start with?
Yeah, so a really important one for us, Ben, is when your superannuation trustees send you a statement, whether that's in the post or by email, turn to page 2. That's a bit tongue-in-cheek, Ben, because most of us will look at page 1, see how much money we've got, see how the return was, see how much those pirates have taken from us in terms of administration fees and investment fees, and then nobody tends to turn to page 2. Page 2 is what will tell you if you've got a binding nomination in place and what your insurance distributions will be. So I know what to look for because I've read heaps of them, but I can almost guarantee you that most people don't look at that section of their statement and understand whether they've got a nomination in place. If you've got any sort of nomination and it doesn't say binding, then please do something about it. In a retail superannuation environment, your nominations actually expire every 3 years. So you've really got to stay on the ball and keep them up to date. Obviously, I think people should dust off whatever documents that they think form their estate plan are and find out, A, how old they are. If they're more than 5 years, seriously consider actually going and seeing some professional and getting them looked at. And have a think about basically what we've talked about today in terms of what constitutes an effective estate plan, and understand what you've got and what you don't have, because some people assume if they've got a will and an enduring power of attorney that they have an effective estate plan, and they've unfortunately got this I guess, false level of comfort that they're protected and that their wishes will be abided by. But nowadays it's a little more involved than that.
Yep.
Number 3 for me, Ben, because I'm hogging this question.
No, go for it. This is 3 things you think the people can do. You're the expert.
Yeah, good. You can have your 3 in a minute. Yeah, sounds very strange for me to say, but go and see your accountant. So much of this estate planning work is driven by the trusted advisor. The most trusted advisors we see are either your financial planner, financial advisor, or your accountant. So we get involved in lots and lots of estate plans on instructions from accountants, who are the ones who've had that initial meeting with family members, and collectively they've decided to go and engage some specialists to finally get this thing done. We've been talking about it for years. Let's get it done. I often find that if there's some accountability from another advisor, like an accountant or a financial planner, you're much more likely to action the plan, and you're much more likely to implement and finalise the whole process. So my advice would be, go and see whoever your most trusted advisor is, and if that advisor is a financial planner or an accountant, they're going to introduce you to someone who really knows what they're doing, and they can get things started.
And empower them to follow you up.
Yeah, that accountability is important, Ben, because lots of people talk about it. I know well in your practice. I mean, how often did this come up in terms of your annual reviews or your half-yearly reviews? It tended to be an agenda item, didn't it? And
it did. Well, we were all about building wealth, protecting it, and then being able to transition it to the next generation. So if you didn't have an estate plan in place and something went wrong, it was a disaster for that process. And I think a couple other things for me, Tim, is number one, is talk to your kids about what's in the estate plan. I mean, I respect the fact that for some people it's going to say, look, I just don't want to do that, or it's not going to be a good idea. But I think the earlier you can, start talking to your kids about what your estate plan looks like and massage those problems out from the start, the better off you'll be. And you obviously need to be a little bit gently, because sometimes the discussions can be a little bit tough, but it's better to have them up early and set the expectation. And I think the other thing I like is, if you're thinking, have I got a problem, is gather all your documents together. So do up a spreadsheet of your assets and liabilities, and do up a bit of a spreadsheet of all your documents. So your will, your power of attorney, get them all together. And then when you do go speak to your professional advisors, take all that stuff with you. And before you go in, have a think about, what do I actually want to have happen? There's nothing worse than going and sitting in front of your lawyer, and, lawyers charge by the hour, and you go in and they say, what do you want to have happen? And you have no idea. You just, shrug your shoulders and say, oh, I don't really know. I think that's really important, to give it a little bit of thought. You don't need to know all the answers, but you need to be able to at least say, well, look, in principle, this is what I'm trying to achieve. And I think the last point for me is that I think it's really important to think about estate planning as a transition. It's not just about, when I die, this is going to happen. If you're in a business, or you're in the business of farming, you don't want to be just saying, okay, well, when I die, all these assets go over to my kids. You might want to talk about, okay, well, we need a succession plan. We need to, transfer these assets over time if it makes sense. And so I think it's really important to treat it like that transitional plan, rather than just an event that happens when the documentation comes into place and set in place my wishes.
Yeah, really good points, Ben. And sometimes the best estate plan implementation is to gift assets while you're alive. And I know we've previously done a podcast about how to financially help your loved ones and next generation and that type of thing. And that can often be a catalyst for considering your wider estate plan, to say, well, if we ramp this up, this is probably going to affect, at the end of the day, if we've given Ben more than we've given Tim, then we need to really square the ledger if that's our preference. And the way we do that is those tools in the toolbox.
Yep. And the last point I'd like to make is, there's more than one way of skinning the cat. So you go in and you see someone and you think, oh, this is an insurmountable problem, I don't know how I'm going to deal with this. As you have said a number of times, there's plenty of tools in the toolbox. There's plenty of ways to skin that cat. You just need the right people around you to give you those solutions, and be tenacious enough to be able to get to the end of the process, get it in place, and get it done.
Yeah, you're spot on, Ben. That too hard basket is a real objection overcomer amongst people. Lots of people come to us and say, I've put this off for 5 or 10 years because I've got a blended family, or I'm in business with my son, or, there's some big ticket complexity and they just don't know how they're going to resolve that. But we've got lots of ideas and we've got lots of ways that we can see it working. So really urge anyone who's been putting it off because they're worried about the complexity of it or they think there's no solution to the situation, there are lots of options and go get some advice.
Absolutely. And get that advice from your accountant, your lawyer, your financial advisor, and make sure those advisors understand your world. So if you're in the rural space, make sure your people understand rural, because there's no point going to a lawyer that doesn't understand all the complexities with rural. If you're in business with companies and trusts and entities, make sure your people know how those things operate. So that's fantastic. Tim, we are going to talk, I believe, fairly soon, I'm hoping, about death taxes, which is something that's becoming really topical. We're starting to see politicians talking about the potential of taxing people when they die. And I think that'd be a great topic for us to talk about, because I know you're a specialist in not only estate planning, but also tax. So I think that'd be a great topic for us to talk about, Tim.
Looking forward to that one, Ben.
Perfect. Excellent. Now, Tim, again, where can people find more about you online?
Website is the best way to start. We're www.rhrivett.com.au. Rivett has a V. And yeah, if you Google us, you can track us down that way.
Fantastic. Well, thanks very much for your help today, Tim. You're a wealth of knowledge, and I know we've only just scratched the surface, but I hope hopefully that's given us enough information to make us actually take some action.
Thanks, Ben. Thanks for having me.
I really enjoyed doing that podcast with Tim, and I look forward to our next episode when we'll be talking about death taxes. Now, a few of the key points or takeaways I got from the episode. Number one, a will and enduring power of attorney on their own is not necessarily an estate plan. Number two, you might not think you have enough money to worry about a will, but if you've got superannuation, there's a chance there's some life insurance in there, which can often be substantial. Number three, superannuation normally falls outside the bounds of your will. So you need to make sure you've got the right documents in place and have considered where that money is going to go when you die. Number four, if your family has a business or a farming enterprise, there's a fair chance they have either partnerships, trusts, or companies involved. It's critical they are included in the estate plan because there can be some real tricks in there. Number five, work with your accountant and your lawyer, and if you have one, a financial advisor, especially if you want to get the best outcome for your beneficiaries. Number six, empower one of your professionals to make sure the estate plan is actually finalised. They will need to keep you moving, especially if you get stuck. And if your accountant, lawyer, or financial advisor is not doing the job, there are other companies and people out there that can actually help you do that. Number seven, consider talking to your beneficiaries about what's in your estate plan before you die. It's better to work out the issues now than the family relationship's being permanently damaged when you die. And you might have to get some help doing that. It can be emotive and it can be challenging to do, but don't put your head in the sand. Number eight, you should review your estate plan every 5 years with a lawyer, and you need to make sure that lawyer's got a deep understanding of estate planning. And finally, number 9 is, above all, get advice. Don't listen to what Tim and I said today and try and guess what you need to do. This isn't personal advice. It's just general information, and you need to really go get some professional legal advice on all these things. Remembering that small little changes or things you might put in place can have massive unintended consequences. Now, I'm really starting to enjoy doing the podcast, and I'd be eternally grateful if you'd help a bloke out and share this episode with your friends and family. And also, if you're listening on Apple Podcasts or Spotify, a review or a 5-star rating would be absolutely amazing so we can help more people. You can also join our new private Facebook group, The Financial Blokes Wealth and Wisdom. And that's it for today. Thanks for joining me again, and I'll catch you with a new episode in 2 weeks' time.